There, I'm Clifford Bates, and welcome to Reading Carl Schmitt. Today, we're starting on legality and legitimacy. Now, legality and legitimacy is one of Schmitt's works after concept of the political. It is written in 1932, and it's written during the crisis that's happening in 32 in Germany, which is the breakdown of the parliamentary system, or the parliamentary crisis, because of the rise of the Nazi parties growing. Starting in 1920, the crisis of 28, 29, the economic crash. The Nazis before 20, basically in the mid 20s, the Nazis kind of ceased being a political power. It was a party that had very almost non-existent representation in the Reichstag, but the economic crisis led both the extreme parties, both communists and Nazis, to gain representation, and that by the to the point where the Nazis were probably by the 32 election, the Nazis were the biggest bloc within the Reichstag, and this is something Schmitt feared. This idea that Schmitt is a Nazi is, at best he's not. He joins the Nazis in 33 after the Nazis have gotten power and get control of the state, and particularly after the Enabling Act. Okay, the Enabling Act after the Reichstag fire, which establishes the total the Hitler's control of absolute sovereign control of the state. That Hitler and the chancellor, as through the Reichstag emergency decree, the Enabling Act, um, gives him kind of quasi very much things of dictatorial power, which Schmitt, in his book Dictatorship in 1921, talked about, and his book on the constitutional theory, which is, I can't say the German word that really good, Verfassungsrechtler. It's Verfassungsrechtler theory of the Constitution, right? In 1928, shaped his thinking about warning about this danger of it. In fact, this echoed his 1921, what is it, the Parliamentarians 923 book on which is translated in English as Crisis of Parliamentary Democracy by Miss Kelly, Dr. Kelly, Eileen Kelly, who has a good book on constitutional crisis of this period, right? Her book on constitutional crisis is worth looking at. But the Parliamentaris of 1923, which is his argument that parliamentary structures are not really democratic structures. And again, this leads to his 1932, first 28, his, remember, this is interesting that his constitutional theory, written in 1928, in his first draft of, uh, of, of the concept of the political. The concept of political is then reissued. He reissues it as a book, revised book, slightly revised, in 32, and this becomes the great moment. And therefore, what we get here with 32 here, with the revisal of concept of the political, with legality and legitimacy, addressing the crisis of both law, what is the crisis within law and legitimacy of the law and the state. Um, we're going to be looking at this thing now. Therefore, I gave you that basic introduction of this so that we see the context by which we are looking at this question. So let's go through the introduction. Okay, let's go through this introduction. Legislative state system of legality compared to other state types: jurisdiction, governmental, and administrative states. Now, if at the outset of this essay about legality and legitimacy, the current domestic political situation in Germany is characterized in terms of the public and constitutional law as the collapse of the parliamentary legislative state. and then that is meant only as a brief, specialized scholarly formula that summarizes development. Now, again, the notes here, I can't go, this is not like this. I have to go, hold on. It's a little, I'm going to have problems here. So let's go over here. Dun, 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 sorry. No, notes. Yeah, this is that. Okay, now we're going to skip here, not the introduction. Sorry, blah, 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 blah. His introduction. And these are the Stadt right? This is, and therefore this is the word Stadtrecht, the constitutional law, right? Or because Stadtler and Weimar period did not involve constitutional rights, it would be misleading to see it as equivalent to constitutional law. They would argue, and this is the editor's kind of position here. For history of Stadtrecht as indicative range of meaning, see Günter Gunder's Handbuch der German Stadtrecht of 1932. And therefore, this is the paralyzed parliament. This is like here, he says here, the majorities of the thing like which I talked about, right? Again, this is the notes are more the editors here. They're not Schmidt's. I'm going to go back. So I'm going to just not use them in that sense. I thought it would be a little different. I mean, when I read this, I haven't really looked at this since about 10 years ago, 15 years ago. So this is kind of a refresher to this to me. So therefore, optimistic or pessimistic suppositions and prognoses are not of interest here. Various crises, whether of the biological, medical, or economic variety, post-war crises, crisis of confidence, those involving health, puberty, weight loss, or what have you, will also not be considered. So therefore, in other words, suppositions and prognosis is not the issue here. And crises of all types are not. He's not going to look at the question of crisis. To correctly understand the entire problematic of today's legality concept, the concept of what law, the nature of law, legality, what makes law legal, right, and the legitimacy, right. To understand the entire problematic of today's legality concept and of the parliamentary legislative state, which is again the parliamentary structure and how the parliamentary model of democracy that forms legislation, as well as the pre-law legal positivism. So therefore, before the war, the legal positivism, which is that again the idea legal positivism is that the law is founded on the dictates of the state, of the ruler. In other words, it is the legislative entity, the body, the state body, with its legislature, in its willing act of the willing of the agent's legislative actor, creates the law. Okay, that's positive law. That it's ruler made law in that sense. The sovereign made law. That the idea here that this is not law based on natural law, that within the nature of human nature or customary law of customs of that. Um, 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 or kind of an emergent law from the customs and habits or actions of peoples that the state helps settles, but rather positive law, like Roman law. Roman law is the conception of this kind of positive law. But modern positive law takes it more extreme view because Roman law took custom as the point, but took the idea of codifying it, right? Codifying custom. So this idea of a law as code, and positive law does this through the act of the legislature, right? The act of the political actor. So therefore, this idea of this in German law, the positivist law, right? It is necessary to define the concepts of public and constitutional law one has in mind regarding the connection between present-day domestic political circumstances in the state. So we have to have a clear understanding of the concepts of public and constitutional law to understand to understand the present-day political circumstances and the nature of the state and why it is. By legislative state, I mean a particular type of political system that is distinctive in that norms intended to be just are the highest and decisive expression of the community's will. So therefore, this idea of legislative state is where that the norms, the norms that are going to be imposed or followed by the community, are intended to be just, are the highest. This is, in fact, this is neo-Kantianism in that sense, right? This is kind of a neo-Kantian definition in that sense. And the role of Kantianism, and particularly neo-Kantianism, in shaping German legal thought at the end of much of the last part of the last part of the building of the Reich, the Wilhelmine Reich, is not important to underestimate, particularly the reform of it, and then the Weimar period, the response at the breakdown of the war, and then the Weimar period. In other words, and the critique by the neopot of the, it's what we call the positivist or neo-Kantian critique of Wilhelmine law becomes the kind of model of the modern democratic principle. Right? This is the kind of argument, and therefore what we have here is a kind of his point about this. Right? These norms, therefore, must exhibit certain qualities. All other public functions, affairs, and subordinate areas must be subordinated to them. So therefore, these norms are the most supreme thing, and everything else subordinates to them. What in continental European states since the 19th century one understood as the Rechtsstaat, so this is the state of law, the law state, right? The, was in reality only a legislative state. Specifically the parliamentary legislative state. So therefore, in other words, if you look at the 19th century continental states, these were the parliament, what is called the Reichsstaat, was really, in fact, legislative states, and particularly parliamentary legislative states. The superior and central position of the parliament was based on the fact that as parliament, the lawmaking body, one established the one established norms with the entire dignity of the lawmaker, of the legislature. In other words, the one established norms with the entire dignity of the lawmaker, of the legislator, right? The lawmaker, legislator in the French. This is Rousseau's legislator. Right? This is why, in many ways, Schmitt is relying a great deal on Rousseau here in Kant. As you know, the role of Rousseau in shaping neo-Kantian thinking on this is actually, important in this sense, to understand the Reichsstaat in that sense. There's a whole argument: what is Reichsstaat? What is the Staatler theory of state? This is one of those big things in German law that kind of differs from Anglo-Saxon law. Everyone wants to blame. I mean, there's kind of view in certain libertarian anti-state circles and among Claremont people about in their progressive myth, the idea of the progressive administrative state as a product of Germanic thinking. But no, we can argue that's a misreading of what Stadtler is. Stadtler, in many ways, and also Reichsstaat thinking, emanates within the Hobbesian Lockean context. If you look at this, and this is why we have to understand this, and even though modified by Rousseau, Rousseau is still working within the Hobbesian context. He clarifies and modifies some things, but he's within the social contract thinking of a reformed conception of the social contract thinking. But his model is kind to rectify this, and Hegel's the same way. Kant and Hegel are still children of Hobbes, as Locke is. Okay. So therefore, there is this idea of this following the Hobbesian state, the logic of the Hobbesian state. So let's continue. The legislative state is a state type governed by impersonal, that is, general and pre-established norms that are meant to be lasting and that have a definable, determinable content. A state type in which the law and legal application, lawmaker and official responsible for legal application, are separated from another. So therefore, the lawmaker and the executive are separated from each other to some degree, right? In other words, well, let's be careful that there is definable distinct a typical state in which the law and the legal application, okay, the lawmaker and officials responsible for legal application are separated from one another. Okay, I think that, okay, this is what he means, that there's a distinction between the legislative and the legislative and its enforcing and the law and the body that deals with legal application, the law, uh, the courts, right, the legal system. That the legislative system and the legal system are separated. This is this. In fact, this is that famous point by Anton Scalia in his testimony in Congress, in the before he died, a couple of years before he died. The late Anton Scalia Supreme Court talked about, well, that in European they don't separate this. This is the that there's the European countries do not separate legislative and executive power. They actually unify executive and legislative. What they separate is judicial, and this is what I think Schmitt is talking about here. The continental model, the European continental model, or the parliamentary model, fuses legislative and executive power, but it separates judicial power, right? I mean, it's the courts, right? So law governs, not men, authorities, or non-elected governments. Okay, so therefore, a law governs, not men, authorities, or non-elected governments. More precisely, laws do not rule; they are not. They are valid only as norms. So the laws are norms. There is no ruling and mere power at all anywhere anymore. In other words, there is no ruling or mere power anymore. Whoever exercises power in government acts on the basis of law or in the name of law. So therefore, law is the dominating norm. It authorizes, it legitimates. Everyone who acts or executes something only acts on the basis of law, right? Um, or in the name of law. He does nothing other than what a valid norm permits jurisdictionally. Law establishes a legislative organ. However, this lawmaking body does not govern directly, nor does it execute laws itself. It merely establishes a valid norm in whose name officials bound by statute to enforce the law exercise state power. The organizational realization of the legislative state always leads to the separation of law and legal application. So there's a separation of law and legal application, the legislative and the executive. So there is this idea of separation. There is the separation of law and legal application, and the legislative and the executive. It is not merely a theoretical separation, but and not merely a psychologically grounded precaution against human lust for power. It is the direct necessity, constructive, fundamental principle of legislative state, in which not men and personal rule, but rather where norms are valid. So therefore, it's not human beings, not human actors are valid, but norms. The norms that are principle will be the dominant power, and therefore you need to have the separation of legislative, this separation division here, right? Finally, so there's this technical separation between the executive and legislature. But there's a problem with that executive legislature division, because if you look at most parliamentary models, that doesn't really work in that way, except the American model. American model is the weirdest one. It is the most extreme of this model, right? But most parliamentary models don't have that, right? And what he's saying here um, uh, is saying that this is not merely this division of power is not merely a kind of a psychological divide to prevent the lust for power, to kind of protect against the domination of powerful people. It is the direct necessity constructed of this principle that not where not men in personal rule, in other words, in personal rule, and norms rather than men rule. Right? The final actual meaning of this fundamental principle of legality of all state life ultimately lies in the fact that there is no longer any government or obedience in general, because only impersonal, or any, in other words, any government or obedience in general, because only impersonal valid norms are being applied. So therefore, government, this is what is interesting. He's arguing this is the new theory of state that's emerged, that post-Wilhelmine idea, the positivist. And this is what he's actually presenting kind of the Kelsen position here. The Kelsen and the Proust position of what's going on here. This argument that he raised in both political, mostly in political theology, with his critique of certain liberal theories. Pardon me. No. We're having a 30 degrees in Celsius outside day. It's like, warning, warning, heat. And this is not air conditioned, so it's not that bad here. So let's continue. Right? Um, in general, legality of, let's look at this principle, and it being valid norms are being applied. Right? In general, legality of all state exercise of power lies the justification of one such state type. So therefore, this is all the things where this idea of the legislator guaranteeing this, and that this legislative state, the legislature is the authorizing entity that deals with it. The executive serves at the will of the legislature, and the law, but the judiciary is independent. This is interesting. The judiciary and the executive are both kind of agents executing the law. The difference is one executes the function and policy of directives of law, and the other one acts as the base by which the questions of law and disputes about law, and also the enforcement of law in terms of criminal law, or the different scopes of law, criminal law, civil law, and the like. Right. This is so therefore, it's all tied to this one state type, right? A closed system of legality grounds the claim to obedience and justifies the suspension of every right of resistance. In other words, that there's no right to resistance because you're being legitimate. You are being represented by your legislature. The legislature is a product of you, the people, right? In this regard, the specific manifestation of law is the statute, while legality is the particular jurisdiction of state coercion. So, therefore, legality is the particular justification of a state coercion. So, therefore, the manifestation of law is statute, and what justifies the justification by which the state enforces through coercion the statute is legality, the law. There are other systems in which the decisive political will emerges in other forms and procedures. There are jurisdictional states in which the deciding judge in the legal dispute has the last word. So there's jurisdictional states, right? Rather than the norm settling legislature. So that's one thing. So that's he's giving other systems, right? So therefore, the legislative state is one thing. The idea of the jurisdictional state, where the deciding judge in legal matters are the last word, then the norm-setting lawmaker. Once again, there are other political forms, governmental or administrative. There are other political forms, governmental or administrative states. So political forms, governmental or administrative states. So that correspond to the specific manner in which the final decision is expressed expressed concretely. Sorry, not concerning. Expressed concretely, and through which the final authority, the dernier ressort, the French word. I think this is French. The last resort, right? The last resort, the final authority of the last resort appears. So therefore, this last resort, the final authority, or the last resort, appears. It is ultimate decider, right? The typical expression of the jurisdictional state is the discretion of the concrete case, in which correct law, justice, and reason reveals themselves directly, without having to be mediated by pre-established general norms, and which, as a result, do not exhaust themselves in normative of legality, in the normativism of the legality. So therefore, an emergent structure, where the legality, the law does this and this imposes this way. It's a bottom-up approach. He's saying that the jurisdictional thing, right? The typical expression of the legislative state is the predetermined, enduring general norm, the substantially definable and determinable. So that this is, in other words, the typical expression of the legislative state is the predetermined, enduring general norm, substantially definable and determinable. In the course of the application of such a norm, the jurisdictional decision, the decision of a judge or a legal actor, shows how all state life generally should be comprehended from a closed system of legality, possibly made possible by the submission of particular factual circumstances in the concrete case. Right? So, in other words, that he's following the law, what the law says, and he's, in other words, this shows how state life should be comprehended by the legal structure of legality, that is the comprehensive system, subsumed in the fact of this particular case. So, when the facts of the particular case are given, what the law says should happen, how should we rule? The jurisdictional state seems to be a Riksdaten inferior, a state of law, a state law state, inferior to that, Riksdag, insofar as it is the judge directly generates legal doctrine, and also applies this law to the norm setting legislature and its laws. So, in other words, this is the idea that the jurisdictional state is a right state, in that it's how the judge generates legal doctrine that also applies to the law, applies this law to the normative setting norm setting legislature and its law, so that these laws and decisions by the judges making decisions based upon the cases. This is, actually, what he's kind of describing here is common law, isn't he? This is what I think in the way common law operates within the Anglo-American experience, right? I think that is what he's putting here. Okay, so therefore, this is that other end, right? At the other end of the spectrum, from the legislative states, stands the governmental state, which finds its characteristic expression in the exalted personal will and authoritative command of the ruling head of state. So, whoever is the head of state, this is the governmental state. So, therefore, we have a jurisdiction, the legislative state, where legislative supreme, the jurisdictional state, where the judges and the way they make law in the case law make this, and then the governmental state, where the exalted personal will and authoritative command of the ruling head of state finds its characteristic expression in this. And yet, there is still another conceivable state type, the administrative state. Okay, so that's the fourth. This is administrative state, in which command and will do not appear authoritarian or impersonal. Okay, the administrative state, in which command and will do not appear authoritarian and personal, and which nevertheless does not seek the mere application of higher norms, but rather only objective directives. So therefore, they're not implying higher norms, do not seek the mere application, but merely only objective directives. In the administrative state, men do not rule, nor are norms valid as anything higher. Instead, the famous formula, things administer themselves, holds true. Even if that may be a utopia, an administrative state is also conceivable whose specific expression is the administrative decree that is determined only in accord with circumstances, in reference to the concrete situation, and motivated entirely by considerations of factual, practical purposefulness. So, actually, this is a very interesting claim here. Historically, and let's continue. That's historically, of course. Next paragraph. Historically, of course, linkages and mixtures. So, therefore, let's stop. He's basically given us the four criterias of the states. So, legislative state, jurisdictional state, three, the kind of a governmental state, and last of all, but the administrative state, right? Historically, of course, linkages and mixtures continuously appear. Therefore, linkages in this, because legislation as well as adjudication, government, and administration is part of every political system. In every state, there is not only there is not only obedience and command, but also the establishment of statutory norms and administration through internal decrees. So therefore, there's not only obedience and command, but there's also the establishment of statutory norms and administration through internal decrees. In other words, statutory norms usually are created by technically statute by law legislatures, whereas administrative through an administration through internal decrees is administrative, right? Relying on Richard Thomas, one can. This is a German thing, a legal thing of the period, 30s, right? A text at his time, so he's responding to contemporary. Schmitt is he's a lawyer, a constitutional theorist, responding to other constitutional theorists. This is in this way. This is a very much not a text. It's a text of the moment, not really a text in the tradition, arguing to larger people, right? One can also discover in every individual state action an element of legislation as well as of administration and even of judicial decision. So, therefore, in any state action, there is both legislative and state of action. There is elements of legislation, lawmaking, the legislator, administration, therefore administrative decree, right, and judicial decision. Okay, in this aspect, specifically, all of these elements and manifestations of state action are reunited in the sovereign. So the sovereign has all these powers, right? The sovereign composed of all these actions. The sovereign is the highest legislator, judge, and commander simultaneously. He is also the final source of legality and the ultimate foundation of legitimacy. So the sovereign itself. In weak states, a legitimate government would gladly make use of the positive renaissance from the legality of the lawmaking body's decision. So a weak state, therefore, the legitimate government would gladly make use of the positive renaissance from the legality of lawmaking decisions. An administrative state, for example, will use judiciary in order to sanction its political measures. Nevertheless, it also remains for the most part self-evidently clear where the focal point of deciding will lie, which of the different possibilities is central for the normal average life, and which type of the highest will emerges definitely or decisively at the key moment and determines the system type. So therefore, he's saying this is this line. This is that one long sentence, right? Let's look at this for a second. Let's think of this. Nevertheless, it remains for the point, most part, self-evident clear, where the focal point of deciding will lie. So, which of the different possibilities is central. So, therefore, what is the thing? Is clear where the focal point of deciding will lie, which is the different possibilities is central for the normal average life, which the highest and which type of highest will emerges definitively or decisively at the key moment determines the system type. So therefore, this is again the sovereign here. He's saying that the sovereign is that thing that decides, right? Makes the power. A suspension, a combination or confusion of the highest court, government, legislative, or administrative is also certainly possible. In transitional intermediate periods, there is perhaps even a fortuitous balance of the several types of mutually dependent highest powers. So these three things might actually be in in a transitional or intermediate period. There might be a balance between these, but the sovereign will ultimately decide which is what. The distinction of the legislative state, its closed system of legality, and the types of legitimacy from the types of legitimacy, such as jurisdiction, governmental, and administrative state, from the types of legitimacy, such as jurisdictional, governmental, and administrative states, themselves all differ from one another, seems to be more fruitful for knowledge of the contemporary state than distinctions developed in previous contexts, such as the antithesis of state and society, authority and freedom, Riksstaat and dictatorship, etc. So he's saying that this distinction between these four, that of the administrative, the legislative state, the governmental state, the jurisdictional state, the governmental state, and administrative state, is more fruitful to understand the problem in our current situation. Is more fruitful to understand this context of these four. This the context is saying about 1930s Germany, of the crisis of the breakdown of the parliamentary system, right, and the rise of this. Um, um, then the antithesis, the so-called duality of state and society, authority, freedom, Riksstaat versus dictatorship, etc., etc. Also, the traditional triad of monarchy, aristocracy, and democracy, with their variants, will not be used here. So we're not going to be using either this typology, these oppositions, or the even the typology of the type of rule, right? The three-pole typology. It is not that the Aristotelian thinking is not modern and has been superseded. So he's not saying that this is. It is not that this is have superseded. However, today the normative fiction of the closed system of legality emerges in a striking and undeniable opposition to the legitimacy of an instance of will that is actually presented and in conformity with the law. So in other words, today, however, the normative fiction of the closed states is in striking and undeniable opposition to legitimacy of an instance of will that is actually present in conformity with the law. This is currently the decisive contradiction, rather than that between the legitimacy of monarchy, aristocracy, oligarchy, and democracy, which mostly only obscures and confuses the current, I think, the situation here, the current situation. Moreover, our state form is undergoing a transformation. So the state form is going, and the turn towards the total state, characteristic of the moment, instead of 100 years ago towards freedom. So in other words, the total state, now freedom. Right? 100 years ago, the movement was towards freedom. Now the total state, right? Seems typical today of the turn towards the administrative state. Okay. So therefore, the total state is the administrative state. By its nature, the total state is an administrative state, even if it makes use of judiciary and indeed the full gamut of legal forms, such as criminal, civil law, civil service regulation, and administrative and constitutional adjudication. Um, or whether it is an instrument of or as a corrective. That in particular, an economic state cannot possibly also work as a legislative state and must become an administrative state almost is already almost universally known today. So, what is he saying here? That this is that the nature of the administrative state is total state. He's basically saying, and that even so-called economic state is an administrative state in that sense. Very interesting in that sense. To what extent the core of every state lies in administration is another question. Both Plato's Republic and Aristotle's Politics are, as Lorenz von Stein said, teaching about stateless societies, and therefore those without administration. So therefore, stateless societies. Very interesting, stateless societies. Um, and that the rise of the state becomes. This is maybe the point. It is the rise of administration emerges with the rise of the state. Now, I'm going to argue that there are offices in the ancient thinking, the offices, Aristotle's Politics, book 4, he makes clear the offices exist. And that the offices, and therefore, remember, are not offices the foundation of administration. But no, the idea of administration lies within the Hobbesian Lockean framework. The rise with the state in its evolution in the Lockean Hobbesian framework, particularly post Hobbesian, particularly post Lockean and the development, mostly Hobbesian, but working through the continental legal frame versus the common law frame, right? Max Weber considered the administrative cadre a defining feature of political association generally. So therefore, so Weber's idea that this administrative cadre, the bureaucracy, is the defining feature of political association. The close connection between state and administration enters our historical consciousness. Sorry, there was a glitch on the system. I had to fix it. Um, Historical consciousness most clearly in the 16th and 17th centuries when the evolution of political systems occurs. So therefore, this is interesting. 16th and 17th centuries, Hobbes, Locke, Machiavelli, the creation of the modern state, right? The 16th and 17th centuries. This is right in the beginning of this moment. Post-Machiavellian, Bodin, Grotius, Bodin, then Hobbes, right? Hobbes becomes the point. So therefore, this is the idea here. So that the connection between state and administration enters in our historical context most clearly in the 16th, 17th century. Not from 19th and 20th, not Hegel, Locke, Hobbes. Okay, this is fun. I think this is a very useful corrective to the Claremont view here, everyone. Um, okay. When the evolution of state political system occurs, associations and forms of states differentiate themselves from legal communities of the medieval state of legal guarantees. In other words, in forms of legal communities of the medieval state of legal guarantees, right? And Fritz Kern's expression, uh, through their well-functioning bureaucratic apparatus, the court, the judges. Otherwise, the parliamentary legislative state, with its separation of statute law and legislative application, presupposes for statutory application an executive that operates in conformity with law, but which, despite its subordination to law, is still independent and distinguishable from other organs. In other words, it's still independent and as from other organs. So it's not completely; it's separate. But even though it depends on this, it is at issue here is the specific system of justification in which the state administrative apparatus stands. And in the 17th and 18th century, that was the dynastic legitimacy of the absolute princes. in in times of stable views of justice and consolidarity property holdings, the jurisdictional state predominates. So, therefore, in stable times of justice and conciliatory consolidation of property holding, the jurisdictional state predominates, and the judiciary, separated from the state, reaches final decisions as guardian and guarantor of the law, which is not merely distinct from the state, but is also prior to and superior to the state. So this idea of the court, the judge, the courts, the judiciary of a judiciary that is not separated from this state, but also is kind of superior to it, right? Is both prior to it and superior to it. In such a system, one can hardly still speak of the state because there is a mere non-political community in place of a political unity, at least according to the fiction. During periods of great change and even transformation, a government, administrative, or depending on the type and duration of the change, even a parliamentary legislative state appears, whose norms seems at best able to facilitate adaptation of law to changing living conditions and encourage a connection between progress and legal certainty. So therefore, this is saying what? That therefore there is this idea, this jurisdictional thing being supreme, stable time of property holding. You have the rise of a court becoming the ultimate the caretaker of this. There is a determining of the rule of the court that it's above the state actor. But this is a fiction, he's saying, because there's not a state proper in that sense. It's a transition. You might be he's saying that during periods of great change or even transformation, a governmental, administrative, or depending on the type of and duration of the change, even a parliamentary legislative appears, right, whose norms seem at best to facilitate the adaptation of law to the changing living circumstances and encourage a connection between progress, this progress in terms of what's happening better, the betterment, the improvement of things, and legal certainty to make sure that there is certainty here, that this progress is bounded on legal forms and frames. So the different state types are appropriate for various domestic political tendencies. In general, one can say that a consistently administered jurisdictional state with its highest activity in court decisions is the proper means of conserving the social status quo and acquired rights, corresponding to the often demonstrated conservative tendencies of each and every instance of adjudication. The corrupt forms of these regimes, in an Aristotelian sense, the type of state that would make it, I think that is Latin, reason for existing, right? A reason for existing. The guarantee of acquiring rights would be characterized by the following saying: everything is okay. Everything is sinecure, which I think this is. Sorry. Everything is okay. There's no definition for it. I think this is everything is a thing, but no longer secure. Everything is something that's been authorized, but nothing is secure. Um, um, the government and the administrative state both adapt themselves more readily to the use of instruments of radical change, whether revolutionary or reactionary, and as comprehensive, systematic planning for relations intended to last for the long term. So administrative, in other words, he's saying that governmental and administrative states are more used for the things that are going to be radical change, whether revolutionary, reactionary, and for complete systematic planning formulations for long term. The legislative state is the typical vehicle of a reformist, revisionist era armed with a party program, which attempts to bring about progress through the appropriate statutes passed through a legal parliamentary channels. So therefore, it's reformist. This is so reaction. So therefore, the sensitive type that makes it guarantee rights would be characterized the following: everything is secure, but the government and administrative state is more radical for this, and the legislative state is. So he starts out this: the governmental administrative state is long radical and reactionary, and long term. Legislative is it's kind of reformist, progressive through parliamentary channels. Now, the ethos of the jurisdictional state is what is the status quo? The status quo is the jurisdictional state, right? The jurisdictional state is the status quo. The ethos of the jurisdictional state is that the judge renders judgment directly in the name of law and justice without mediating the mediation of norms of justice from others, non-judicial political power. In other words, it just does to the law, not from norms of other non-judicial political power. Right? That is simple. That is a simple principle, and is illuminating so long as law and justice have unambiguous content, without intervening norms, are not merely tools of the powerful and of the propertied interests. So therefore, in other words, they can't be just merely tools of the. They must have what he says that as long as law and justice have an unambiguous context and without intervening norms, without and are not merely tools of the powerful and propertied interest. The governmental state does not have so much an ethos as a great pathos, right? Ethos, ethos, habit, and pathos. Okay, what is pathos? Ethos, an ethic, or things like this, habit, but as a pathos. Its principle became most visible in the government of the absolute princes of the 17th and 18th centuries, particularly in the catalog of representative emblems of princes, who clothe their personal realm with words like majestas, splendor, excellenta, eminence, honor, glory. It is the great pathos of glory and honor that the Prussian administrative state of Frederick William I and Frederick the Great could not deny itself. Already in the 17th century, the Republican democratic virtue opposed the governmental state's government's principle as a polemical counter concept against honor, seeking to disqualify the representative quality of honor. So, in other words, a counterpart. In other words, that the democratic Republican principle of virtue, the democratic virtue, opposed as a polemic thing against honor, seeking to disqualify honor and to expose representation itself as mere theater, while Republican democratic virtue set the harmonious people's democratic and self-identical presence against the representation of the prince and his court. So therefore, the people, in other words, In other words, it showed that the theater, well, in other words, equality of honor and expose representation itself to mere theater, right? While the Republican Democratic, oh yeah, maybe that's the problem. The prince, the occasional representative, and to expose representation as a mere theater, right? This is the counter. In other words, the governmental state principles as a polemical counterpoint against honor, seeking to disqualify or represent quality of honor and to expose this idea of representation as mere theater, right? The other system, right? And this is going to be this virtue set the people's homogeneous as people's democratic and self-identical presence against the representation of the prince and his court. At the same time, however, one also made use of the specific ethos of the properly norm-setting legislative state with its just laws, its wise and incorruptible legislator, right, legislator, and it's always good and just. Okay, general will. Yeah, will. General will. General will. Yeah, good and just general will. Remember, this is the sovereign, right? This is the general will is the sovereign, the legislature in that sense. The administrative state can call on faculty necessary, the condition of things, the force of circumstances, the necessary of the moment, and other non-normative situation-specific justifications. So therefore, the legislative state goes on this, but the administrative state can call on the now, the situation, the fact, the facility of necessity, the condition of things, the force of circumstances, the necessary of the moment, and the non-normative. Okay, this is. Oh, I think this is correspondingly. The administrative state finds its existential justification in the purposefulness, the usefulness, and in contrast to the conformity to norms of the normatively grounded legislative state. The grounded, directly concrete, factual appropriateness of its administrative measures, orders, and commands. So, in other words, corresponding administrative finance its existential justification in purposefulness, the usefulness, and in contrast to the conformity to the norms of this, right? The direct, concrete, factual appropriateness of its administrative measures. So it is more concrete, more specific, more things. Let us instead of too general, this is going to be more specific. Both the governmental and the administrative state perceives a distinctive quality in concrete commands, which are directly executable or easily obeyed. And they make an end of the advocate's plea they make an end of the advocate's plea accompanying the jurisdictional state, as well as the parliamentary legislative tendency towards endless discussion, recognizing already the decisionism of the immediate executable directive as a legal value in itself. Right? This idea that a immediately executable directive is a legal value in itself, self-executing decree. In this regard, it still holds true. The best thing in the world is command. Rudolf Schmitt argues that liberalism, along with parliamentarism, based on it, has no unique pathos, no claim to value, and therefore no legitimating power particular to itself. So Schmitt argues this is notice. Liberalism also does not need to make any effort at all to develop a corresponding legitimization for itself. And this is because this idea of the rights, right? This idea of rights, in that sense, right? But one must not overlook the fact that the parliamentary legislative state, with its ideal closed and gapless system of legality of all state action, developed a thoroughly distinctive system of justification. Legality here has the meaning and purpose of making superfluous and negating the legitimacy of either the monarch or the people's plebisciting will, as well as of every authority of governing power, whether in the form that provides its own foundation or one claiming to be something higher. So therefore, it denies any kind of higher claims, either that of the monarch or the plebiscite, right? This idea that the law, legislative entity itself makes what is this act, this deciding act here, makes it the norm in that sense. The law itself is the norm, right? If in this system, if in this system words like legitimacy and authority are still generally used, they are only used as an expression of legality derived from it. Max Weber's principles of sociology should be understood in the same way. Legality can legality can be valid like legitimacy. Legality can be valid like legitimacy. Or the most widely prominent form of legitimacy today is the belief in legality, right? This is Weber's point. Here, legitimacy and legality are traceable to a single legitimacy concept, whereas legality is in direct opposition to legitimacy. So therefore, in other words, here both legality are traceable to a single legitimacy concept, whereas legality is in direct opposition to legitimacy. I accept, therefore, Arthur um, uh, Kirchheimer's formula in an essay about legality and legitimacy, that the legitimacy of parliamentary democracy resides only in its legality. And today, obviously, legal restrictions are equated with legitimacy. So, therefore, obvious legal restrictions are now with legitimacy. Linguistic usage, linguistic usage today has certainly already proceeded so far that it perceives the legal as something merely formal and in opposition to the legitimate. So, therefore, the law itself that legal is only something formal, this is like this, and legitimate is this something different, right? The opposition to legitimate in that sense, and people's willing it to be. Without this sense of contradiction, for example, one can today consider the dissolution of the Reichstag strictly legal, even though it is, in fact, a coup d'etat. And vice versa, a parliamentary dissolution might substantially conform to the spirit of the Constitution and yet not be legal. In other words, and vice versa, parliamentary dissolution might be subsequently conform to the spirit of the Constitution yet not be legal. Such antitheses document the breakdown of the system of legality, which ends in formalism and functionalism without substance or reference to or reference points. So therefore, it's a formalism and functionalism without substance or reference points. Such a result is only explicable in reference to the forsaking of the essential presuppositions and the specific pathos of the legalistic concept of law. So therefore, as essentially forsaking the essential presuppositions and the specific pathos of the legalistic concept of law. These changes give rise to the illusion that one can open legal channels and the legal process to all conceivable aspirations, goals, and movements, even the most radical and revolutionary, enabling them to achieve their aim without violence or disrupting through a legal process that establishes order, while at the same time it functions as in a complete value neutral way. So this is this. Okay, this is that moment. This is the insanity of liberalism, right? The suicidal of the liberal view that these changes give rise to the illusion that one open legal channels and the legal process of all conceivable aspirations, goals, and movements, even more radical and revolutionary, enabling them to achieve their aims without violence or disruption through a legal process that is supposed to be neutral. Okay, this is the distinctive rationalism of this system of legality is obviously recast into its opposite. So therefore, the distinctive rationalism of the system is opposite, right? This process essentially characterizes the current situation of parliamentary legislative state. This is the current situation. This idea of legality is this value neutral and trying to that anything that can do and try to do the emphasis legality of this. Subsequent chapters will provide complete and detailed explanations of it. With regard to the concept of legality, one must keep in mind, both historically and conceptually, that it is a product and a problem of the parliamentary legislative state, and it is specific, and it's specifically type of normativism. So the normativism of in other words, the specific type of normativism that emerges out of the parliamentary legislative state. So in other words, the regard to the concept of legality, we have to keep in mind historical conceptually that it's a product and a problem of this thing and a specific type of normative. The concept of legality inherits the situation established by princely absolutism. So therefore, in other words, he's saying that this concept of legality inherits the situation established by princely absolutism. Specifically, the elimination of every right to resistance and the grand right to unconditional obedience. In other words, you can't resist, you can't do this, you must obey, right? It inherits that. So you can't have violence, you can't have revolution, but you can have change through the system of law, and law will be value neutral. Oh God, that's upsetting, right? Um, okay. But the concept of legality provides the parliamentary legislative state the dignity of legality, which it creates through general pre-established norms. So therefore, it creates legality through these general principles. The jurisdictional state and the administrative state remains in the closest possible direct communication with the actual concrete situation. And consequently, they have a certain concrete presence. The governmental state has all the qualities of representation in the person of the chief executive or in the dignity of its directive body. The legislative state, by contrast, is placed in an altogether different sphere by virtue of its dominant principle of the general pre-established norm, and its essentially distinction between law and legal application, legislation and executive. It suffers through from a certain abstractiveness. In other words, it suffers through a certain abstractness. But the legislative state seems to have seems to be something higher and ideal, so long as the belief in the rationality and ideal, ideality, ideality, ideality of its normativism, its norms and principles, is still vibrant in times and in peoples, both in times and in peoples, that remain able to cultivate a typical Cartesian belief in the ideas, general ideas, right? As long as the people are able to believe in the general ideas of these norms, it will hold together. At the times the people are able to believe in the ideas, general ideas of these norms, it will stay stable, right? And we look up this idea. This is also the case as long as the legislative state can call on several thousand-year-old distinction and realize the ancient ethos, above all that of the nomos against the mere thumos, and spiritedness of thumos, thumos, thismos, thismos. The racial reason against the mere voluntaris, the voluntary, the mere, in other words, the thumos, the involuntary, right? The thing that compels versus the mere voluntary. So therefore, the reason against the ratio against the voluntas. The Okay, that's Latin. Voluntary, right? Intelligence versus the blind against the blind will. The mind reason against the blind will. The voluntas, the blind will, right? Without a basis in norms. Without a basis in norms. The idea of the law backed by justified norms against the administrative measure and command, both based on mere practicality and dependent on changing conditions. So therefore, this the idea of law backed by justified norms, right? These ideas against administrative measure and command, both on mere practicality and dependent on changing conditions. Semicolon. Reasonable rationalism against pragmatism and emotionalism. Semicolon. Idealism and just law against utilitarianism. Validity and moral command against coercion and force of circumstances. So these are the kind of parallels, the oppositions of this idea that this is the power of the parliamentary legislative state. In that sense, it has the norm of this. It is able to deal with the ideas. It is able to deal with this tension between nomos and thumos, law and spirit and reason versus you know the willing agent, the voluntas, the intelligence against the blind will, right? Without a basis of blind will without the basis of norms. The idea of law backed by these norms against the administrative measure and command, both based on mere practicality, dependent on changing condition. Right? These two things are both on practicality and condition. Reasonable rationalism against pragmatism, emotionalism, idealism, and just law against utilitarianism, validity and moral command against coercion and force. From the perspectives of the legislative state, the representative, the governmental state, and its glory and its honor appears to be a mere power state, and immoral, immoral. The administrative state, a dictatorship unbound by norms and without spirit. The medieval jurisdiction state, a vehicle of feudal and estate privilege hostile to progress. So this is the classic arguments, right? This is from the legislative point of view, the the governmental state is a dictatorship, right? No, is the power state, and it's immoral, right? The administrative state is a dictatorship unbound by norms and without spirit, and the jurisdictional state is just a vehicle of feudal interest, right? The legislative state can make reference to the fact that the effective and legitimizing formula in the name of the law is not transferable, least of all to the measure of to the measures of the administrative state. There is no equality before the measure, as there is equality before the law. So there is, in other words, the name of the law that is not transferable to the measure of the administrator. There's no equality before the measure. There's equality before the law. I can also, I can, I can also not apply law, impose sentences, or generally act authoritatively in the name of practicality or factual necessity, or in the name of the force of circumstances instead of the name of the law. So I can't, in other words, I cannot impose sentences. I cannot apply law, impose sentences, or generally act authoritatively in the name of practicality, factual necessity, or in the name of the force of circumstances instead of the law. Right? It would be obvious grotesque if one announced court decisions in the name of the measure instead of that of the king, of the people, or of the law, or if one would swear an oath to the measure or affirm loyalty to the administrative directives. In other words, okay, like the king, the people of the law. Right? This is grotesque in that sense. This is the grotesque aspect of it. The state civil service and armed forces, when they are being considered only as technical apparatus in the hands of the government, are by themselves neither a distinct source of law nor a ground of legitimacy. The civil service and armed forces cannot alone support the administrative state, which naturally requires a bureaucratic apparatus. In contrast to so therefore, it's not. In other words, we cannot understand. In other words, the administrative state is not the armed. It's not. This is the problem. I think the deep state, the military and industrial, the security, the military and national security state. All right, this is the bureaucracy, right, and the civil service, right. These are not the administrative state. These are only what apparatus. These are only what he says, the apparatus. The civil service forces cannot alone support an administrative state, which naturally requires a bureaucrat. They're the apparatus of the state. In contrast to the different state forms and types, the bureaucracy often exhibits the neutrality of a mere technical instrument, which, with certain reservations, such as regards for the acquired rights of officials, can serve various, even contradictory political directions. So, yes, the civil service can be, in a sense, neutral, right? Yes, indeed, the civil servant must be versatile, says Roman Schmitt. In a supposedly value-neutered category of Max Weber's sociology, the term bureaucracy, above all, has the meaning of permitting the bureaucracy to appear as a technical, rational, value-neutral machinery of an official apparatus principally interested in the bureaucracy's smooth operation. This interpretation certainly stands in a thoroughly polemic relation to the situation of pre-war German state, and brings the German professional civil service as something non-political technical into an unfair opposition to parliamentary an unfair opposition to parliament, which Max Weber famously held to be a mere held to be the means of selecting political leaders and forming elites. In other words, the parliament was merely famously held as a means of selecting political leaders and forming elites. In other words, it's electing leaders and forming elites, not anything else. The French expression involving something truly instrumental. The parliamentarism of the French Republic obliterated the idea that the army and the civil service themselves have legality and legitimacy, or could develop them on their own. And it discredited fundamentally both the connection within the dynastic legitimacy of the royal house, as well as the Bonapartist linkage with the plebiscite democratic legitimacy. So, therefore, it destroyed the legitimacy of the royal house, the Bourbon family, the royal house, right, as well as the Bonapartists' attempt to link a linkage with plebiscite democratic legitimacy, right. In Germany, the civil service of the 19th century participated in a large number of constitutional monarchies. Absent unto today, consequently, has been the direct organizational connection with the entirety of national unity, and with the parliamentary representation of the whole German people in the Reichstag. So therefore, in other words, it was their local monarchy. What was missing, absent until today, consequently, has been the direct organizational connection with the entirety of the national unity and the parliamentary representation of the whole German people. The distinctive property of the constitutional monarchy entitled the civil service to support substantially the foundations of a monarchical legitimacy, as well as the legality of the legislative state. One must not overlook what Hans Gerber recently showed at a meeting of teachers of public law in Halle during 1931. Specifically, without the without the firmly guaranteed positions of the civil service. This type of Riksdag, the law state, that is the legislative state, would not have been conceivable. So without that, the firmly, in other words, the guaranteed position of this made the legislative possibility. Gerber's correct observation, I believe, expresses the historic fact that the professional civil service can also be more than a mere apparatus which functions under the control of any given system. More accurately, elements of a genuine elite in the sociological sense of the word, an elite that is capable of producing authority and legitimacy, could be born through a professional cadre that creates stability and entrusted with the guarantees of public interests. Such an elite would have qualities like incorruptibility, separation from the world of striving for money and profit, education, sense of duty and loyalty, plus certain obviously diminishing tendencies towards cooperation. If these three necessary conditions, stability, qualities, and self-recruitment, are the marks of a state reinforcing political elite, then one may view the German professional civil service of the 19th century as an elite-like factor in German state life. Only that precisely, precisely the decisive quality of every political elite, the German life, only that precisely precisely that distinctive quality of every political elite, the arbitrary willingness to risk the political, the ability and willingness to risk the political, in other words, to engage in power, is not evidence. Therefore, that went to challenge the thing. That it was an elite, but it wasn't going to challenge the authority of the emperor, the king. So it's that. So therefore, this is not okay. This is once the dynastic legitimacy of the constitutional monarch disappeared, the German army, with after its disarmament and demilitarization of the German people, was no longer an army in the traditional sense, and the national civil service, especially the new created financial bureaucracy, found the possibility of a new basis and plebiscite legitimacy of the German parliament, elected by the entire German people. Because it lacked this foundation, the civil service of the individual German states is occupied to a great extent by the forces of the pluralist partisan state or party state. Okay, that's it. This is German. Hold on. Party state. Yeah, it doesn't. That's not a dictionary. The partisan state. I think partisan. Okay, let's look at this. That's the idea of legislative consequences, competence of the German states, and with it the space for parliamentary legislative state is not sufficient enough to make possible an independent system of legality for these states. That the different German land governments, having varying interpretations of public security, order, and hostility to the state, is bound up with the fact that a share in the political premium on the legal possession of power, discussed below, page 35 of this thing, fell to different powers today. Considered under the concept of legality and legitimacy, the German professional civil service today is no longer a unified whole with its own distinctive political significance. Nevertheless, given the absence of another authority, the individual parts of the German civil service could become a focal point of the strong need for and tendency towards an authoritarian state. and the civil service on its own could attempt to produce order in an administrative state. A large chunk of the governing administrative class has already developed the practice of legally binding emergency decrees in accordance with Article 48, Section 2, which has been in use for over 2 years. What this development in parliamentary legislative state means will be explained further below, Part 2, Chapter 5. Um, um, of interest here is that when it is transformed into an empty functionary of momentary majority decisions, the normative legality of parliamentary legislation can be linked with the impersonal functionalism of bureaucracy, necessary regulatory necessities. So, therefore, in other words, transitory minority, the empty functionalism of the momentary majority decisions. This normative parliamentary body can be linked with the impersonal functions of bureaucracies and therefore address like a regulatory aspect of immediate needs, right? In this particular, though, practical alliance of legality and technical functionalism, the bureaucracy in the long run remains the superior partner and transform the law of the parliamentary legislative state into the measures of the administrative state. The word Reichsstaat should not be used here. Both the legislative state and the jurisdictional state could present themselves ipso facto, themselves as a Reichsstaat. But this is also true of any governmental and administrative states when they actually rely on themselves to develop law in order to replace unjust old law through proper new law and, almost importantly, to create the normal situation, without which every system of norms is a deception. So you need a normal situation. Every system of norms is a deception, right? And without which the normal situation, as every system of norms is a normal deception. You need a normal situation. Norms are necessary for this. So you need to have this. The term Reichsstaat can mean as many different things as the word law itself. And moreover, just as many different things as organizations concoct different things as organizations concocted by the term state. There is a feudal, a state-bound, a bourgeois, a national or social, or further a natural law, or a rational law, or historical legal form of Reichsstaat. Pardon me, I need that. My throat is drying up. And this has been longer than I thought it would be. It is conceivable that the propagandists and advocates of all types could, in other words, therefore, these are different types of law states. There's more. The feudal, the estate base, right? Feudal and estate base. The bourgeois, a national, a social, and further, a natural law or rational law, and an historical legal Reichsstaat. And conceivable that propagandists and advocates of all types could claim that the word for their own presupposes in order to denounce the opponent as the enemy of the Reichsstaat. So therefore, every one of these things will see the enemy or the alternative as an enemy, and therefore the enemy that they are the Reichsstaat, and therefore the other ones. So the Reichsstaat is simply just any kind of structure of this thing. All of these entities can call themselves Reichsstaat. The following saying applies to their Reichsstaat and concept of law. A law should above all be what I and my friends value. Is it our democracy? Oh my God, this is so powerful. With the help of the distinction among legislative, jurisdictional, and governmental and administrative states, one ascertains specific characteristics. So therefore, with the help of distinction among the legislative, jurisdictional, governmental, and this that, one ascertains certain specific characteristics through which the concrete distinctiveness of the system of legality and and its current position can be better and more clearly recognized. Right? And this we ends the introduction. Okay, this has been a good chapter. It's been long. I apologize. We've had breaks in it because of some problems. Um, I hope you have any questions. Please put the questions below, and when I see them, I'll talk about it. If you like it, please, and share it on social media. Hit the like button, share on social media, get your friends, post it to your friends, bring it to attention, get some attention on this. This I think is useful to hit on. Um, Another thing is, if you didn't like it, okay, you can say no, but put your comment down on why you didn't like it. That's how we can learn. We can all learn. We can all benefit. If you have not subscribed, please subscribe. If you know, and if you know people who are interested in this, bring this channel to their attention. Bring this to their attention. Get them to sign up, because this is the only way the channel grows and we get more looking. I'm doing this to educate people. This has been, and actually this has been interesting to those who want interested contemporary concerns about the so-called administrative state. Today's introduction has been very, very good in terms of this. So, um, 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 so please subscribe. Another thing you do, if you want to follow me on social media, link below. Another thing you can do is, if you want to help what I do here to share that and do what I do, you can kind of contribute through Subscribe Star and Patreon. Okay, you can send me money. Please, please, please. I could use a patron. I could really use a patron right now because the money's been really ridiculously tight. But this is the life, right? That's life and inflation, right? But then again, Patreon, subscribe. But another thing where you can help is go buy one of my books. They're listed below. That's there. Again, these videos, Schmitt is on Tuesday, Thursdays. We're still finishing up Montesquieu on Monday, Wednesdays, in this sense, and every Fridays there's some kind of either a live stream or a kind of messing around thing. So I let you go now. That's it. Take care, and we'll see you next time, where we'll look at, as he says here, part 1, chapter 1. Right? Okay. Take care. Bye. Bye. Have a good day.